Hi, my name is Courtney Brennan, and I'm an associate in the Burns-White Litigation Practice Group, where I focus in the areas of employment, business, and complex and commercial litigation. I hope you enjoyed this segment from a recent webinar, and I hope that you find it helpful. But another very interesting trend we're seeing emerge has to do with wage and hour claims. By this point, we've all probably gone through the experience of standing in line to either have your temperature checked or sign off on COVID-19 screening questions before being allowed to enter either your workplace or a store or the doctor's office. But recent class actions are starting to emerge where employees are claiming that they were not paid for waiting in line for these precautionary screening measures. And more specifically, they're alleging that the time spent waiting in line was working off the clock. Now, one of the bigger examples we're seeing was filed against Walmart in California just 2 months ago. There, the workers are asserting that Walmart asked their employees to arrive 30 minutes before their shift to stand in line for temperature checks and a coronavirus symptom check, but does not pay them for that time spent waiting and the extra time that they need to be at work. Now, this case is not unique. It's not an issue that's going to appear to go away overnight. It's very common, especially right here in Pennsylvania. There's a case regarding Amazon before the Pennsylvania Supreme Court regarding the time employees spend in security lines and whether or not that time is compensable. So now what we're seeing is cases such as those regarding either a security line or meal breaks or the time that employees spend putting on protective gear for their shifts. Now they're going to start tacking on a COVID-19 claim of the time spent, fulfilling these pre-screening questionnaires or putting on their PPE or standing in line to have their temperature taken. So it's going to present an interesting issue in the class action world. We know in federal court under the Fair Labor Standards Act, there's 2 key questions as to whether or not that time spent before or after work is compensable. And those questions generally are whether whether that conduct is a principal activity. So in this case, whether taking an employee's temperature would be a principal activity, and whether the time spent waiting in line by employees to have their temperature taken is a preliminary or post-preliminary activity. Now, a critical question of all of these Fair Labor Standard cases deals with kind of defining when the beginning and end of a workday exists. But, the biggest trend we're seeing, like I said, are plaintiffs who are bringing these non-COVID related class actions and now starting to tack on the COVID claims. So it's certainly something that employers should consider as the financial risks have now increased, and employers would be doing well to review their compensation and timekeeping policies, especially to make sure that they are in compliance.